going on? How's everyone doing?
Shout out to Colin and everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Wednesday. Happy Wednesday. Yeah, halfway through the week. Hopefully, you guys had a great start to the week. There's only 2 days left. Well, for the normal work week, I think a lot of us work more than just till Friday. But, anyways, glad you all are here. I've got a good one tonight. I've got a pro se facing a judge. This is a final pretrial. This is not the trial. I tried to make that clear in the thumbnail in the title. This is not the trial. The trial is next week. This is just the final pretrial where this pro se guy, defendant, is just he's asking a lot of dumb questions, and I don't know why the judge just doesn't shut it down. It's like this isn't going to work, but it's interesting to watch this part of the court process, just to watch how dumb some people are sometimes. But yeah, this is how you lose your trial before it starts. You go pro se, and yeah, I think the prosecutor is gonna, essentially call in sick this day and just write the whatever he's gonna talk about the night before. Anyways, this one's fun. But before I do get started, giant shout out to all of you for helping us hit the goal for Muse's GoFundMe. It's actually not Muse's GoFundMe, it's Muse's ex-wife's GoFundMe, but Muse, yeah, you guys know the story. But thank you so much, everybody. You guys are awesome. I do appreciate it. I had something else I wanted to say. Oh, I've got the pro se guy, and then I've got the update to Mr. Magoo that happened to Judge Washington yesterday. I was debating playing it. Yeah, it's kind of boring, guys. It's kind of boring, but you know, I think at least a couple times a week someone asks me what's going on with Magoo, and well, we have an update, so I'm gonna play it. So that's coming on after the pro se guy, pro se defendant. I think I had something else I wanted to say. Talked about the case, talked about Muse, talked about the Mr. Magoo. There was something else I can't remember. So you know what? Let's just play it, and we'll it might pop up. It might pop up. Someone did leave a comment. Maybe that's what it was. Trying to find it real quick. Someone said something. I want to respond to it. Where'd it go? Where'd it go? Oh, this was it. I don't know if that's a joke on her name or if you're just asking because I haven't played her in a few days. So Judge Brown, and I don't remember the male judge's name. I don't remember his name off the top of my head. But they rotate days. So Judge Brown handles all the landlord tenant cases and the civil cases, and then the guy I yeah, I don't remember his name, but he handles all the like traffic. He does all the traffic stuff. So they kind of rotate days. Sometimes we'll see Judge Brown 2 or 3 days in a row, and then we'll see the other judge a couple days in a row. But that's why, like, she's not there every day. She's not the sitting judge. It's still technically Judge Garcia's courtroom, and they're just filling until the election. Which I feel like I heard someone in court say that they have a special election happening maybe in a month. I think maybe. I mean, it's soon. I feel like it's soon. But that's the update. All right. I think that's it for the intro. So before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick back flips. Let's go.
Christopher Edmonds.
This will be State of Indiana versus Christopher Edmonds, 64D01, 2509F49779. Defendant is present. Pro se states represented by Deputy Prosecutor Hammer. We were set for pretrial today with a trial on next Tuesday.
Morning, Mr. Edmonds.
Morning, sir.
Sir, I got a letter from you the other day. Let me make sure that I pull it up here before I start. I remember one thing was that you're having some trouble getting clothing that you require for the trial?
Correct.
And you're having some problems with your vision.
Vision problems.
Right.
Early right now.
I don't know why that letter's not in my file. Oh, I see it here. There's just been a lot of stuff out since then. Yeah, I meant to text the warden and ask him about this eyeglasses thing. You can't get glasses from out there?
I have an ex-girlfriend that said that she just moved here to Valparaiso. She said that she found a pair of contacts while she was packing and moving.
Yeah.
Then her and I had a little argument on the phone, and she had hung up on me.
Yeah?
Now I can't get a hold of this girl. And
Oh.
that's
I mean, one of the problems with representing yourself is that, especially when you're in custody, is that you can't do all these things that you would normally have a lawyer do for you.
Yes,
Just
sir.
coordinate getting stuff like this, bring it out to the jail, coordinate getting the clothing and things that you need so you can have that out of the jail and all that. It's just a difficult position. And I mean, the only thing I can really do, the jail already knows that they have to help with your preparation for trial, but they don't have to help insofar as like going to get clothing for you or trying to figure out this contact lens situation. This is a you problem, right?
Yes, sir.
So the only thing I can really offer you is a continuance.
Would it be an option for me to wear the clothes I was arrested in, maybe?
Potentially. I don't know what you were arrested in, but you should be able to.
Work clothes, but
Yeah, I don't know what it is, but it's probably more becoming than the orange jumpsuit you're wearing right now.
definitely, Your Honor. You also instructed me.
I love it. We're already off to a good start. This is a you problem. Yeah. You don't have glasses and you can't find your contacts. You don't have clothes. Yeah, this is a you problem. You went pro se. Sorry.
To write you a letter regarding some phone calls, my jail call log records,
Yeah?
to help me receive them, and I have not heard nothing back regarding them call logs.
Here's another letter. Your January 22nd letter to gain global Tel-Link phone records
Yes,
from
sir.
the Porter County Jail between you and your mother, right? And then I had received some subpoenas from you. Those were all sent out. You didn't ask to subpoena those records from the jail?
I believe I did give you a subpoena for that.
Okay, so you're asking to enforce the subpoena?
Yes, sir.
Your Honor, I looked through what he filed and I do not see one for the jail. I may be mistaken, but I saw it to DCS Judge Tody, Portage Police Department, but I do not see any for the jail.
Yeah, I don't see it either. So I don't see that you've made a request for that.
Okay. Your Honor, I also sent a
If you send your summons, I'll get it out. Subpoena, rather, subpoena. Go ahead.
Portage Police Department has given me a hard time about receiving some body camera footage. It would have been August 29th of 25 for the same address that's here on file at 3025, which I wrote them a letter. They said that they needed a specific time, which I have no idea what time they were there. I just know that they were there on the 29th regarding me. And they're requesting a payment. I'm unable to pay any, type of funds from jail. They're giving me extremely hard time about receiving this evidence that I need. And I don't
Okay.
know if the court may be able to help me with that. But
Yeah, again, I mean,
Highly
these are
appreciate
things where if you had a lawyer, they could try to work through that issue if it was evidence that you really needed. I would need a motion to compel. Your oral motion to compel is one thing, but a written motion to compel the production. You're also running out of time, though, because this trial is going to be next week.
Yes, sir.
So if they need advance payment, usually they need advance payment. That's not something where they're just being difficult to you. That's an administrative requirement they have to be able to release video because it costs them money to have to produce all that.
Even just a police report, you know, their call.
Even a police report
service.
costs money. I don't know how much their agency costs because I haven't gotten a police report from Portage for a long time.
Okay.
But I could see them wanting, you know, 15, 30, 50 bucks or whatever. I don't even know how much it is, but yes, they typically require you pay for that type of information. And that's another reason it's helpful to have somebody on the outside. But in any case, yes, whatever their administrative requirement is for you to be able to have those documents, you have to abide by that. Same thing if you're going to have people come testify at trial, right? I can send subpoenas for you for testimony at trial, but if you're going to have people who are like professionals, they're still expecting to be paid a certain amount of money to come. I'm just not sure who you're going to have coming.
Yeah, no, I don't need any professionals.
Okay.
Got a lot of witnesses here, but the state also sent me out some letters the other day, and they mentioned about. It's hard for me to go through this, but they mentioned some evidence that was not sent in. And as you know, I've been mailing everything from the jail. It takes some time, but I did send some evidence in to you just recently.
You can't send evidence to me, but what I will do now is go through the motions that have been filed by the state. One of those motions is the list of witnesses. Did you receive the state's list of witnesses?
Yes, I have the list of witnesses.
Okay, and you know who all those folks are?
Yes, I do, Your Honor.
Okay. Thank you, state. And then I have the state's exhibit list.
The only thing I know about Crocs is the movie Idiocracy caused them to blow up. That's really all I know about Crocs. And yeah, I've never owned a pair. Don't know what they feel like on my feet. They're just a piece of rubber, right?
State, have you provided the body camera footage you intend to share with the jury to the defendant in this case already?
Yes, we did that quite a while ago.
Okay, I just want to make sure. Okay, and you received the list of exhibits as well, Mr. Edmonds?
Yes, I did, Your Honor.
You're satisfied with the information on the list of exhibits versus the information you have in your possession related to the discovery process?
Yes.
Okay. And then I've got the motion in limine. State filed a motion in limine number 1. They're asking for the exclusion of forms of argument or evidence designated to elicit jury nullification. State, in 100 words or less, explain what you're asking for.
Your Honor, it's to prevent anybody asking for the I may have done it, but you should feel sorry for me, essentially, or disregard the law. Otherwise, asking them to, there could have been a valid court order in place, but I'm asking you to disregard that is, I guess that's the easiest way. You're asking them to disregard the law in one way, shape, or form.
Mr. Edmonds, did you read the state's motion in limine?
I read that one, yes.
Do you have any objection to state's motion in limine number 1?
No, sir.
Okay. 1 is granted by agreement or without objection. I guess I should say granted without objection. 2 is the exclusion of argument or questions pertaining to maximum, minimum, or potential penalties. I'll tell you, Mr. Edmonds, in the jury process, I will never talk about the potential penalty for any of the things you've been charged with. Do you understand that?
I agree, Your Honor.
Okay, and I'm not permitted to. I do the sentencing. If there's a guilty verdict, the jury doesn't even do that in this kind of case. Do you understand that?
Yes, sir.
Okay. So do you have any objection to state's motion limited number 2?
No, sir.
And 2 is granted without objection. And then on 3, this is a question about discovery requests. State, give me the quick synopsis of your 3.
That anything we've discussed about here that either one side has either acted inappropriate or not given you something that you've asked for, meaning either myself or any part of the discovery process, given that that's dictated outside of the court as it is.
Yes, Mr. Evans, they're saying you can't stand up and say, hey, I didn't get this information from the Portage Police Department because they were going to make me pay a fee. Like, you can't talk about that in front of the jury.
There is a lot in this discovery that I would like to go over and question specific witnesses, especially in the affidavits. That's still allowed, correct?
You're allowed to question the witnesses related to the statements they made to the police.
Yes.
That's absolutely correct.
Thank you, Your Honor.
Yeah, but you don't talk about, you didn't get this or that, or you
Definitely.
were expected to get this or that in the discovery and it didn't ever come.
Definitely.
Okay, so 3 is also granted without objection. 4 is about prior bad acts. So on one hand, the state's saying that they aren't going to bring up any information about your prior bad acts unless they give you proper notice, but they also don't want you talking about any of their witnesses or any of the alleged victims in the case and their prior bad acts unless you can do that with the appropriate 404B notification.
Even if a certain police officer has had formal disciplinary actions taken against them in the past?
I mean, you'd have to bring that up in advance and we need to have a hearing about that. Is that something that you plan to do?
I'd like to. One officer here, Officer York.
Do you
I'd
know
like to
what
see
the allegation was against Officer York?
I'm not sure. I'd like to see his history, his record, disciplinary records.
Well, did you make that request, sir?
No, I have not.
Okay,
In your honor, he
you're running out of time, but go ahead.
would have also been outside he would had to have made that, I believe it's 10 days before trial, and we're inside 10 days at this point.
Yeah, that's true. I mean, you are out of time on the question as well. But in any case, do you want me to show your objection to motion to eliminate number 4?
Please.
Okay, so we'll grant that over the defendant's objection. 5 is possible effects on the defendant if convicted. The terrible things that could happen to you if you're convicted, like you would lose your job, you would have public shame, different things like that. That's just not relevant. I would grant that under most circumstances, but do you have any objection to it?
No, sir.
Okay, 5 is admitted, or 5 is granted without objection. 6 is about your self-representation. There'll be an advisement. I'll give the jury about your self-representation, but what the state is suggesting is that you're not going to be able to stand up and say, hey, I'm poor, pitiful me up here representing myself, and you should feel sorry for me because I had to do this, without a lawyer, is essentially it. Is that right, Mr. Hammer?
Yes.
Okay. So any objection on 6?
No objection. Your Honor.
Okay, so motion to eliminate 6 is granted without objection. 7 is affirmative defenses. You want to tell me what you're looking for there, State?
Your honor, kind of similar to his 404B, alibi, any of those self-defense, anything like that, that would have been, he would have had to have alleged well before this point. He has not made those, so therefore he can't talk about them now.
Okay. So any affirmative defenses you would have had to bring to the court's attention at the appropriate time that haven't been raised or filed before the court. Do you have any objection to 7?
Can you, Mr. Hammer, you mind explaining that one more time?
Yeah, I actually have questions. I saw both Dan and Rob in the chat already. So, but if anyone knows the question or the answer to this, I would appreciate it. Why, if you're going to make a self-defense claim, words are hard. If you're going to make that type of claim, why do you have to let the prosecution know before trial? Hey, that seems like, hey, this is my strategy. Why do I have to let them know? Is there statutes or court rules that specifically say if you're gonna use self-defense, you have to let us know so we can be prepared for that? Is that? Hold on, Rob answered the question. You have to put state on notice because it shifts the burden. All right. Okay. Yeah, that makes sense because if you're claiming self-defense, it's this you have to make okay. Rob, that's I am glad we're friends. That makes perfect sense. Yeah. Cuz you're absolutely having to, make the defense that it's self-defense, so you have to prove that instead of the prosecute. Okay. Cuz you're I guess if you're claiming self-defense, you're admitting to whatever violent act there is. So, okay. All right. Thanks, Rob.
There are certain defenses that are laid out by statute and by case law that you have to present before trial, and you can't just spring them like self-defense or alibi or again the 404B, things such as that. You have not made the appropriate motion at the appropriate time, therefore you can't now make them.
He means to be talking to me.
Dr. JD, thank you so much for the 2 years. That is awesome. Thank you. Thank you. 2 years. Speaking of milestones, Rex, thank you so much for the 9 months. I paused it a couple times since you sent this. I'm sorry I didn't shout you out. I'm trying to get better. I'm trying to get back into pausing at specific times to, help the people that are watching later. So, Rex, Dr. JD, thank you so much for the milestones. You guys are awesome.
Mr. Edmonds, but
I'm sorry, yes, sir.
I apologize.
that's all right. So do you have any questions about
No, sir.
7? Do you have an objection there?
No, sir.
Okay, I'm not sure what your defense looks like, but I will grant motion in limine number 7 without objection. 8 is your own character. They're saying that you shouldn't be able to produce any evidence about your good character because it's not relevant. Did you get a chance to review that?
Yes, I did, Your Honor.
And do you have any objection to motion limit number 8?
No, sir.
Okay, 8 is granted without objection. And 9 is self-serving statements, and this is really difficult when you're representing yourself. It's something that you really have to be cautious about. Do you want to explain a little bit better, Mr. Hammer?
Essentially, you can't call a witness to testify to something that you would have to testify to, I guess is the long and the short of it. So if it was something, you can't ask a witness, didn't I tell you that? Blah, blah, blah. Or what did I tell you? You are not allowed under the rules of evidence to do those said statements.
Makes sense, Your
Does that
Honor.
make any sense?
Yes, sir.
Okay, do you have any objection to 9?
No, sir.
Motion limiting 9 will be granted without objection. And 10 is another character question about vouching, right? It's you saying that you're the most honest guy, vouching for your own truthfulness or for the witness's truthfulness. I'm already going to put them under oath. I'm already going to tell the jury in my instructions that they need to accept everything they hear from a witness as true unless there are reasons why they shouldn't that are brought up during the cross-examination or impeachment that's done by either side. Do you understand what they're asking for in motion limiting number 10?
Yes, I do, Your Honor.
I thought I explained it to your satisfaction,
Yes, sir.
counsel, Mr. Hammer.
I think that's
Okay, motion limiting 10, do you have an objection there?
No, Your Honor.
All right, motion limiting 10 is granted without objection. And those are the motions limiting. I granted all of those. I have an amended exhibit list. Did you receive the amended exhibit list? It looks to add, what is this, the property records of Tammy Maldonado? Is that what was added? Or
No,
prior
that
conviction?
was just the certified, I believe it was the certified conviction for his prior, Your Honor.
Okay.
That was alleged in one of the other accounts. We just got the certified
Is that-
documents.
Prior conviction and enhancer here?
Yes, it would be an enhancer to count 6, I think it's, or
Okay.
not count 6, count 4, I think. It's the invasion charge.
Invasion of privacy?
Yes.
Are we trying to bifurcate this trial?
Your Honor, I was not, I prepared for both ways, Your Honor. To bifurcate it and then figure out the court's inclination. Hence why my instructions are a little bit longer, because I prepared for both.
I'm seeing your instructions for the first time right now. You know what a bifurcated trial is, sir?
No, sir.
Bifurcated trial would not let the jury know that you have that prior conviction until we have the second part of a trial on the invasion of privacy charge that brings it up to level 6 felony. So in this case, we would just bifurcate out count 4. Is that right, State?
Correct.
State
It
going to
would
dismiss any
appear.
charges before we start our trial?
What?
Is State going to dismiss any charges before we start this trial?
No, Your Honor.
Okay. So if we bifurcated, we would just try 4 separately. Is that correct?
Yes.
Okay. You understand that, sir?
Yes, I do, Your Honor.
How does 4 work with the residential entry? Let me get the PCA up here. Yeah, I mean, the felony is the invasion of privacy felony on the level 5 burglary.
Correct.
So I think we're trying it all together.
And Your Honor, I was trying to get some guidance from downstate as well. So I didn't have an exact answer for you.
Yeah.
I think they're is it inexplicably intertwined, Your Honor? I think is the phrase I'm looking for.
I think inexplicable is the word you want to use there.
Or in,
Were there amended charges filed later? There's only 4 charges on that first probable
No.
cause affidavit. Oh, there was a 404B motion filed by Worthley all the way back at the front of the case. Do you have any 404B?
no, Your Honor, apart from what was already, apart from what's part of the case.
Okay.
State was not going to intend to elicit much testimony than usually in prior court ruling when available. Unless, again, the door is opened by anything Mr. Edmonds says that could potentially allow for diving into deeper things at his peril.
Oh, I see. They attached count 5 as additional pages after their main probable cause affidavit.
Yes, Your
I
Honor.
see it here. 5 and 6. Yeah, I'll have to look at that bifurcation question as well. It's a difficult one, but I'll take a look at it and get some guidance out. Did you get the state's instructions, sir?
Yes, we did.
No, sorry guys. Apparently I've got an editing mistake in here. I'm gonna fast forward a little bit.
And he said if I get my bond reduced, he'd be able
Sorry,
to
guys.
financially assist me. That's why I wrote you.
And yes, Java Puppy, I know. Reset the Colin makes editing mistake sign to 0. 0 days.
Did you see anything else that I haven't talked about?
Your Honor, I never got that bond reduction, so I don't.
Oh, I see. Motion to eliminate.
This is Indiana. Judge Fish in Indiana. It's a court that I've been following lately. Not a huge one, but I like this judge. I've been trying to venture out and watching a few new courts. You know, trying to liven things up a bit.
Let me get the question first. I denied. Oh, I see. Judge Massey denied a motion for bond back in September. That was because you had a lawyer involved in the case. There's a $10,000 cash bond that was set back on September 4th, 2025. State. Anything on the question of bond?
Your Honor, I don't think there's really been a change in circumstance given what's going on, Your Honor, to necessitate a reduction in bond. However, again, that was on initial determinations made by Judge Massey, so I don't know if you would like to review his analysis before.
There's always time that expires. You know, changes. What would be your argument for bond, Mr. Edmonds, or a reduction in bond?
The purpose of hiring an attorney, the purpose of obtaining, everything that free person could obtain for trial, to, like, fight the case from the outside versus the inside,
Are all these cases in DO6 still pending?
Yes, Your Honor. And they involve the same victim, at least when it came to the battery, Your Honor, which is the part of the no contact order.
I don't know why these cases weren't transferred to this court, but in any event, we'll leave them out there. The other thing, Mr. Edmonds, I don't know whether the state's done it or not, but looks like there are 7 cases pending, 7 cases out in Portage, one of them in front of Judge Drenth and another 6 in front of Judge Tody. There's no reason the state wouldn't ask for your bond to be revoked. So even if I changed your bond in this case, I don't know that it would make any difference. That would be the first move I would suspect would happen. Plus your trial's next week. If you hire a lawyer now, there's no guarantee that they're going to be able to get ready for the trial that's set next week. And there's certainly no promise for me that I would continue it. You've got those pending cases and then 37 other pages worth of matters that were filed with the court as part of the original case filing. Those are all the records that are accumulated, criminal history, if you will. $10,000 bond seems like a gift at this point, given all the charges that were pending at the time of the arrest, the time that $10,000 bond was set. So we would deny the motion to reduce bond at this time. Also, so you can get out and do the work you need to do outside and prepare yourself for trial isn't really a good reason for reduction of bond. There's a letter from the defendant trying to find it now. Have statement by defendant thrown out. Respectfully request not allow the state to use any statements made by the accused to be used against them due to the arresting officers of all Miranda rights. Okay. So you're asking that there be an exclusion of testimony because you weren't properly Mirandized.
Yes, sir.
Okay, you want to tell us more about your argument there?
Excuse me?
You want to tell me more about your argument there?
At no point after I was detained or arrested was any type of Miranda rights read to me that morning on 29th or 31st of August, Your Honor.
Okay. Did you give a recorded statement at the jail?
No, I did not.
Did you give a recorded statement to any investigator?
No, Your Honor.
Okay. State.
Well, congratulations. That means it doesn't matter. If they're not using anything against you that you said when you were arrested or at the jail, yeah. Sorry. That's just one of those weird things that people claim. I don't understand it. I don't understand. There's enough ways to find out information these days that holds no water anymore. Now, I won't lie to you. When I was in high school, that was a thing. We said, "Oh, if they don't Mirandize you, all the charges are going to be dropped." Yeah, because no one understood it. You didn't have a phone in your pocket. You could just quickly look it up, and not everyone was on the internet. Yeah. Anyways, Phil, thank you so much for the 5 gifted memberships. I appreciate it. Welcome to the 5 new members. Phil, you are awesome. Thank you.
Your Honor, barring the fact that he's attempting to file a motion to suppress, which he hasn't, which requires a formalized written motion along, again, with memorandum in support thereof, Your Honor. Any statements he may have met, there are some qualifications, and I'm not trying to explain him the legal benefit of having an attorney. However, there are qualifications for when Miranda has to be read that a attorney would know exactly even in every instance, Your Honor, because not everything is a triggering event. Not just because you talk to police is it a triggering event for Miranda based on the case law, Your Honor. But I'm not going to delve too much into it because, again, he needs to be held to the same standard that the state is.
Well, I understand that. Any further support for your motion, Mr. Edmonds?
Well, like I said, Your Honor, this is a statement that could be used against me at trial. And once again, I was never advised of my Miranda rights that morning, nor at the jail, you know. So I'd like to have that statement suppressed, if you don't mind.
Okay. Yeah, and as counsel indicated, the motion was filed back on January 20th, but you did not include a brief or anything like you're required to supply. The state hasn't responded with anything in response to that request, but it's not properly made. I think, though, the heart of it related to the Miranda question comes up during trial. I don't even know what statements they might intend to use against you, but it would typically be impeachment. Do you plan to testify on your own behalf?
No, not at all, Your Honor.
Okay, so they're going to use statements at different points. I'll deny it as it is drafted here, but it's brought it to my attention and has alerted me to the fact that it might be an issue that could come up during trial, right? So you won't see that in any order from today, but consider me on notice that might be an issue we have to deal with during the trial.
Thank you, Your Honor.
And what's important is that if you know the statements they're suggesting you made to the police that they might intend to use against you, is that you bring that up when the jury's out, okay? That, hey, judge, during this next witness, I think they're going to try to use statements I made. And then you try to bring that up during the trial, and we'll see what that looks like at trial, okay? So in a certain sense, I'm also taking it under advisement that may come up during the trial.
Thank you.
All right, did you file any other motions with the court?
No, sir.
Anything else you need me to consider today, Mr. Edmond?
No, I'm glad you went over the rules with me, and I appreciate your time today.
State anything else?
No, Your Honor.
Have I gone through the pretrial things? Like, you know how jury selection works? Did I talk about that?
No, you have not.
No.
So we're going to have a room full of people when you come in. They're going to bring you in.
I don't know if he's actually giving him legal advice. He's definitely being very friendly to this guy. He's probably just hoping that the trial goes well. The trial's next week. And the reason I'm playing this video tonight is because I intend to play this pro se trial next week. I think it's going to be very interesting. So I can't wait to see it. Now that I'm really excited about it, it might be very boring. I don't know. But yeah, Judge Fish is being very, very friendly to the pro se defendant. And I don't have a problem with it. I don't think he's giving straight up legal advice, though.
And they're going to have to keep you upstairs, but they're going to let you walk right through that door. You're going to have your knee brace on, right? But you're not going to be in handcuffs. And you're going to walk right up through the door and sit down and start working on the case. You'll be sitting over here on this side, okay? Because we keep you separated from the jury. There'll be a room full of people. The voir dire will kick off by me. Well, there's going to be a video first from the Chief Justice of the Supreme Court. Then there's going to be some voir dire. I will kick it off by asking some easy questions for the jury about their qualifications and their real availability for the trial. And then the state's going to get the chance to go. And they're going to have about half an hour on what we call.
He didn't say why he didn't want public defender, but he did request for a bond. He wanted his bond reduced so he can get out and hire an attorney. So it sounds like he just has an issue with the public defender's office. But if he can hire an attorney in jail, I don't know why. It's a week before trial. So there's not going to be a lot of attorneys that are going to take your case a week before your trial. But yeah. Sending text. Oh, you sent me a text? Okay, I'll check it.
Sort of first crush with the jury, and then you'll have a half an hour to ask some questions, talk about some things. It's not the time for you to be talking about the facts of the case, not the time for you to be talking about yourself or who you are. Sometimes people try to develop a rapport with the jury by talking a little bit about what they do and about who they are. Those aren't proper voir dire questions at all. I don't appreciate those kinds of questions at all. So what's important at voir dire is for you to ask questions that help you make determinations about the people you want to kick off this jury, right? You're going to have this whole veneer here with 60 some odd people in the room. You're trying to figure out who you don't want on the jury. There's going to be 12 people in the box already as you start. And then you're going to have 10 strikes that you can make just because you want to make them, right? And then you're going to have 3 strikes you can make. Unlimited strikes you can make for cause.
Okay.
Right? And cause can be for any of those reasons that might come up for cause. Anything you can think of, like that they are prejudiced against you, or that they refuse to take the oath, or they refuse to be fair and impartial, different things like that. And that'll all come up during the voir dire process. After the voir dire, we'll have our jury, and we will start, probably give them a recess. I'll read the instructions. We'll swear in the jury, read the instructions, and then we'll start the trial after that. Okay? There'll be opening statements that are made. Opening statements aren't the time for anybody to make any argument. What you say in opening statement is the evidence will show, the evidence will show, the evidence will show. You never say anything conclusory.
Yes, sir.
Right? Because that would be improper as well.
Correct.
And we go from there. So, do you have any questions about the voir dire?
Yeah, but Lisette, the fact that you're saying that will probably get you eliminated from the trial. Like, if you show up for jury selection and someone starts speaking soft sit and you get really excited, that might be a quick way to get axed off that trial. Just saying, you're gonna have to show up and be, act like you've never heard the term soft sit before. You got to do that, and then it's like, oh yeah, that sounds it. No, you can't even say that because you don't want to sound like you're sympathizing to him either. I don't know what to do. I don't know what I would do if I was in that position. But yeah, I wish I would be in that jury too. But we're already prejudiced against them, right? So for a fair legal system, we're not allowed to be on that jury because we already see through their bullshit. So it wouldn't really be fair. You would have to have a jury of people who have never heard of the sovereign citizen movement.
Your process?
No, I don't, Your Honor.
We mark our exhibits with numbers only. We don't use letters. Okay? So are you going to bring your exhibits pre-marked?
Yes, Your Honor.
Okay, just use numbers. Defense 1 through 800, or whatever you have. Do you have video evidence of your own?
I just got the body camera footage, Your Honor. Plus, I have some personal property that I was arrested with, my state ID and some other cards. Can I have that potentially as evidence at here at trial?
I don't know what relevance your state ID would have.
Proves residency.
How are you going to get that in?
So I was hoping you could answer for me, Your Honor.
No, I can definitely not be a witness for you.
No, you mean how would I get my ID in?
Yeah.
The jail would bring it.
How would you get it into evidence if you're not going to testify?
So I can't.
All right, the judge is walking him through the rules of evidence right now, and I've seen judges do this, just kind of vaguely question it when someone's pro se. It's like, do you know the rules of evidence? You got to know how to do this. But Judge Fish is actually walking through this. And Captain Sides, yeah, I mean, I agree with you, but you know what? I can't think of a counter argument to that because for everyone that's against the movement, people are for it. So fair enough. So they would just ask you, do you know what the sovereign citizen movement is? Yes. Are you for or against it? Against. Okay, bye. I don't know.
Present my state ID to the jury and as evidence.
Not without a witness. You have to have a witness get that in for you. Are you going to testify?
A witness to get it in for me.
Yes.
Well, my mother lives with me. I don't understand
What's she going to testify for you?
She's on the witness list here.
Well, then you would ask her questions about your residency, wouldn't you?
Excuse me?
You would ask her questions about
Correct.
your residency.
Yes. It's just, I figured it'd be a crucial piece of evidence for the jury to see.
Yeah, I mean, I guess you got to figure out how to get it in. But I would, yeah, I mean, personal property you need from the jail's personal property. I'll put in my order here that if you need any of your personal property, including clothing or documents and things from your personal property, you can have access to those for trial.
Thank you. Thank you.
Okay?
Yes, sir.
Yeah. Anything else?
There is one situation. As I'm sitting at the law library reviewing all this footage and other documents, I was hoping I may have, is it a possibility that I could have a second friend assist me at the library? Right now at the time, the jail doesn't allow that.
Yeah, usually not. No.
All right.
Yeah.
there's no way you could order that for me?
Usually not. Like who? Like another inmate?
Yeah.
Usually not.
Okay, no problem.
Yeah. Somebody to assist with your
Just,
preparation for.
there's some things that I may not notice in the video that they may notice. Just
Yeah. See, what's
like I
your
said,
take on
I
that?
would.
What's your take on that?
He's essentially trying to get another person to be a witness for him that he's not intending on either calling or otherwise, and it's a strategic thing which would then necessitate more of a need for a lawyer than just a friend. So I believe it's improper for him to do that.
So you object?
Yes.
Okay. Yeah,
Sorry.
I can't grant that relief, Mr. Edmonds.
No problem.
No.
Thank you.
We'll deny that. Anything else then?
No, sir.
Anything else, State?
Not that the state's aware of it this time, Your Honor.
All right. I will look forward to seeing you both a week from tomorrow. We're adjourned.
All right. That last request is blowing my mind. But I mean, I get it. You know, like, oh, I want to have someone else look over this video and see if I missed anything. I mean, I get it. That makes sense. You know, a second pair of eyes, you might be able to see something that you wouldn't see the first time. Like, yeah, it makes sense. Yeah, you're in jail, man. No, you can't have someone else in jail help you with your case. I mean, it happens. But to actually bring him into the law library, to order the jail to allow someone in there with you, that's weird. That's a weird request. But hey, that's he asked. You know, just because it's weird doesn't mean it wasn't a good idea. It got denied. But anyways, Cheryl, thank you so much for the super chat. I appreciate it. Sorry I'm late. Here's my late fee. Was looking up places to buy a tree. Gonna get a dogwood and I'll scatter wildflowers. Big and chat helping big time. All right, nice. And thank you so much for the super chat. I appreciate it. All right, we're gonna move on. I I'm gonna actually skip ahead because I know for a fact that I forgot to cut off the end of this, and I don't want to be called out for two editing mistakes in one night. So I'm just gonna fast. Yeah, see. Oh, excuse me. Hold on. I gotta mute myself. All right. So we are in Judge Washington's courtroom. Giant shout out to Judge Washington who decided to grace us with a presence yesterday. And as you see, Mr. Magoo is standing at the podium, not in custody. This is Mr. Magoo. I debated playing this, as I said in the intro, because it's not that exciting. It really isn't. He has an attorney. His case with Judge Washington was never exciting. The exciting case was with Judge Simpson, but I wanted to give you guys an update. Again, like I said in the intro, about, I don't know, 2 or 3 times a week, someone asks what's going on with him. And here we go. Is it traffic court? I don't remember exactly. No, this isn't traffic. This is criminal. He's got this is where he has like the tampering charge. Yeah, I don't know, but this is not traffic. Usually Magistrate Braley handles the traffic matters in IPSI. Judge Washington handles the criminal. It's not always how it happens, but usually how it happens. And I think this is a criminal case. I don't think anyways, let's go. Let's watch it. Mr. Magoo, Judge Washington, let's go.
Yes, Your Honor, we have reached a resolution.
Thank you.
Mr. Magoo will be guilty as charged with the agreement that it is a non-reporting probation. He will be complying with the circuit court sobriety.
I am so sorry. I think when I was skipping ahead, I went too far ahead. I just don't want to show there we go. I don't want to show my flaws and show my editing mistakes. I'm trying to avoid it. But then by talking about it so much, now we're resetting the count down to 0 days after it was already set to 0 days. It didn't even last 20 minutes.
Ashley Moten on behalf of Mr. Magoo. State your name.
Good morning.
Bill, you're in person today. How are you, sir?
Good, how are you?
Good. All right, we're here for a pretrial with this matter.
Yes, Your Honor, we have reached a resolution.
Thank you.
Mr. Magoo will be guilty as charged with the agreement that it is a non-reporting probation. He will be complying with the circuit court sobriety court. And it is under the prosecutor's deferred.
That's correct, Trevor, if he successfully completes the sobriety court.
Oh, the deferred is based on him successfully.
Yes, Your Honor.
completing the sobriety court. All right, sir. It's my understanding that you're going to be pleading guilty as charged in this particular case. And we're charged with 2 counts. 1 second. Yes, 2 counts. Are these in the alternative or are they?
2 different victims, Your Honor.
Okay, thank you. One, 2 counts of, one is for telecommunications services, malicious use, domestic relationship, and the other one is telecommunications, malicious use. You're to plead to both of those. One is for Alyssa McCloskey, the other one is for Scott McCloskey. They both carry a maximum penalty of up to 6 months and/or $1,000 fine. In exchange for that, you'll be placed on a non-reporting probation on the prosecutor's deferred. The deferred is conditioned upon you completing the sobriety report that you're at. Is that your understanding of the agreement?
Yes, it is.
And is that what you want to do?
Yes.
Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may lower your hand. I'm going to go over the rights that you have that you're going to be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney again, okay? You have the right to have a trial by a judge or a jury, as which time you should call witnesses, speak for you, and get an order signed by me to require that any and all witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you. You have the right to be a witness for yourself, at which time you, or you could choose to remain silent. If you chose to remain silent, the prosecutor could not comment on it. You have a right to be presumed innocent unless the prosecutor can show by a reasonable doubt, that you're guilty. Do you understand that?
Yes.
Do you understand you're going to be waiving all those rights and you're not going to be having a trial of any sort?
Yes.
Do you also understand that there's no automatic right to appeal this decision? So the decision you're making today in all likelihood is going to stick with you.
Yes.
If you were on probation, parole, or bond. When this happened on February 15th of 2025, you could be in violation of that probation, parole, and bond. Were you on any that you're still on now on that day? Thank you. And if you're not a U.S. citizen, then you could have immigration consequences. Do you understand?
Yes.
Okay. To the charge of telecommunications malicious use with a domestic relationship and telecommunication services malicious use, how do you plead?
No contest.
All right, this is a no contest plea.
That is my understanding from Mr. Duke, Your Honor.
Do you have the police report, Your Honor?
Was
Okay.
probably being held.
Okay.
Okay.
All right, do you understand what no contest means?
Fair understanding.
Yeah, Cynthia, he's always had an attorney for the case he sat in front of Judge Washington. And he's always been very respectful. He has not pulled the soft sit crap. He hasn't done any of this with Judge Washington. And we have a running theory that he behaves in front of Judge Washington because he doesn't know that she also has a online presence. And he acts a fool in Judge Simpson because he's online. That's been the running theory that we've had, or at least that I've had. I think someone in the chat said it and I just agreed with it. And now it's my theory too. But this has always been him in Judge Washington's courtroom. Cool as a cucumber, not talking back, being respectful, has an attorney. Like I said, kind of boring, but update on Magoo.
A fair understanding. Okay, so it means that you're not saying you did. You're not saying you didn't do it. This court is going to treat you like you're guilty, so you're guilty in the court's eyes. You understand that?
Right.
All right. And the basis for a no contest plea?
Okay, so, lack of recollection here.
Lack of recollection is a, valid basis for a no contest plea. No, any objection from the prosecutor?
No, Your Honor.
Thank you. Has anyone promised you anything other than what we placed on the record that you to plead no contest, sir? Sir,
That's correct.
no one's promised you anything else?
Correct.
All right. Has anyone threatened you in any way, shape, or form?
No.
All right, thank you. I'm in receipt of case report number 25004164 with the date of incident.
I was wondering that too for a second. I was like, I didn't want to pause it, but I didn't know what was going on. Like, I know Judge Washington takes about 10 minutes during this to read over the police report, and I thought I edited that out. I think I still did, but we'll see.
I think that's the, oh, it was reported on June 23rd. But the incident was beginning from February 15th to June 23rd. An allegation to this reported to have occurred at the location of 6988 McKee Road here in Ypsilanti Township. Do the attorney stipulate to my use of this report to determine the factual basis?
People so stipulate.
Defensive, stipulates to that.
Give me one moment. Is there any particular party that's that help me to see the Melissa's use piece? It appears that there are a lot of text messages. First, and I have to read them all.
Let me just have a moment now and then.
I can tell you that this is a walk-in report. The defendant has a child in Colin with, it appears Alyssa Plasky and Scott is her husband. They went in to report that they were receiving telephone messages from Mr. Magoo, which were concerning, and provided a copy of those text messages to the police while they were there.
I am looking here. I didn't know we were doing a no contest plea till this morning, so I apologize for not being prepared. Your Honor, based on the statute, one of the ways that we can establish the crime of telecommunication service with malicious use is to use vulgar, indecent, or obscene or offensive language, or suggesting any lewd or lascivious act in the course of the conversation to the use of telecommunication service or device. So that would be a way that we could sustain our burden, based on some of the language in the text messages.
Yeah, where would I find that is what I'm trying to ask, because so far I've read 4 pages and he's talking about his son, which I need to see where the,
Let me see if I can get the page number for your. all the time. Maybe the 10th page, there's two messages on this page. One on the left starts yes with several S's, the random screenshot comment, that page. Specifically the message on the right side of that page
So you're saying page 10?
of the messages, page 16 of the report overall.
Let me see here.
And then page 22 overall.
What are you guys talking about? Someone said a penguin and now we got a scuba gnome. I don't see what you guys are talking about.
And on page 10, and now you're saying page 22. Are we 22 of the messages or 22 as a whole?
22 as a whole, I think starting on page 22 and sort of continuing in 23, 24, 25, we start to see some more language that would support actually that. Okay. I know that the text to Ms. McCloskey and then text to Scott and next set, you'll see there's a break.
All right, the court has reviewed substantial portion of these particular messages. There are many of them that are about the child that do not seem threatening or harassing, but there are some ones, particularly the ones regarding the nature of his baby's mother's.
All right. Yeah. The one bad thing about streaming, well, one of the few bad things, one of the many bad things about StreamYard is my video is only about, I don't know, 3 inches by 6 inches, if that big. I don't know. So it's really hard to see. But my video is really small. Yeah. There's a lot of jokes in there that you guys can break down if you want. I feel like they're coming.
Potential, whether it's true or not, I don't know, past relationships and her employment and the way he talks about her. And there, I want to disparage her on the record, but he said some very demeaning things about her, and he calls the husband a number of names and castrates him in the sense in the messages. Although there are no threats that were used, or very, there are lots of curse words that are used in the midst of the text messaging. Dumbass, lonely loser.
You guys are killing me. I knew it the second I said that out loud. Like, I just opened myself up to that one.
Like there are a number of very derogatory terms that are used towards Mr. McCloskey, and I do find that there is a factual basis for the plea based on those particular comments. There's more, Madam Prosecutor, please feel free to chime in.
No, the people are satisfied that the court has made a sufficient factual basis for the plea.
Thank you.
Defense is satisfied.
Thank you. All right. In light of the nature of the plea, I also find that the agreement in this matter is fair agreement with respect to a deferred. When have you started your recovery court program already?
I've been at since October 16th,
Since October.
with no hiccups.
And people would request a sentencing date, just so that we can give the victim the chance to come in and see if they'd like.
I'll make that on March 3rd
Thank you.
at 10:00 a.m. So you need to go with probation. We'll send a file over now so that you can talk to them about, we need them to have their actual interview, okay? They're gonna interview you regarding this particular man, and then they'll write a report for me to review at the sentencing. You already have basically what that looks like. It's not reporting, but they also need to give me the additional for the actual sentence.
I could have somebody in the courtroom.
Is there anything else we need to address today?
No, Your Honor, thank you.
No, thank you.
Sorry,
Sir.
is there a way I can appear by Zoom? I'm still.
You can submit your documentation through your attorney to request to appear, and then we'll go from there.
He's in the-
All right. All right. That wraps up the evening. There's your update on Mr. Magoo. Yeah, I know. When he stands in front of Judge Washington, it's not exciting. But this is always how he's acted in front of Judge Washington. Respect, not over talking, not interrupting, the same thing. Always had an attorney, said please and thank you. This is always how he's acted in front of her. And I don't know why. It's very interesting the difference between Judge Washington and Judge Simpson when you put Magoo in front of them. But Wixom's here. Did he act like this in front of Judge Slay, Wixom? I would love to know if he just held his tongue and didn't do random things for no reason. Anyways, I appreciate everyone being here. Neil Morrison's in the house. And for 23 months. Thank you so much, Neil Morrison. That is awesome. Thank you. And good to see you. Good to see you. Hopefully you're well. Hopefully you are well. I think that's I think that's about it. No, that is it. I got nothing else. So let's see who we're gonna raid. Who we're gonna raid this evening. I feel like there's gonna be a few choices. So we got Lone Wolf, Katie Zed, Kfar, and that's it. We have 3 options. What do you guys want to do? First option I see we're going to. Lone Wolf, Katie Zed, Kfar. First one. First chat I see. And do we have a winner? Java Puppy said Katie Zed first. Java Puppy's the winner. We're going to Katie Zed. Katie Zed is the winner. All right. Set up for Katie Zed. That being, we're rating Katie Zed. That being said, Lone Wolf is live. Go check him out. Kfar is live. Katie Zed's live. Well, we're going to Katie Zed. But thank you guys so much for hanging out with me tonight. I do appreciate it. Giant shout out to everyone that helped with the GoFundMe for Muse's family. You guys are awesome. I can't say that enough. I need to make an actual post saying that on YouTube. I said it in Discord. I don't use the community tab enough in YouTube, and I need to start using that more often. But thank you so much, and thank you for watching. For all the gifted membership milestones, super chats, you guys are awesome. Mods, as always, thank you so much for your hard work. You guys are the backbone of the channel. But that's it. That's all I got. See you guys tomorrow. Till next time, bye.
We'll give you your notice at this time too.
Thank you.
Yes.
Yeah. Yeah.